Welcome everybody who's with us in person, and welcome people who are joining us remotely. It gives me great pleasure to introduce to you, if you've not met Sir Kenneth Keith. We are going to hear Sir Ken for about 25 minutes and then have a few minutes for questions, we hope. Everybody knows about the 7 fundamental principles, but perhaps our knowledge is a little bit less up to date about the 7 fundamental rules of IHL. And we're very, very privileged to have with us one of the most distinguished experts on international law in the world, and also a very long-time ally of New Zealand Red Cross, to introduce us to these 7 rules. Sir Kenneth was a New Zealand judge, or is a New Zealand judge, and he was appointed to the International Court of Justice in November 2005, and for his entire career has been a very great friend of New Zealand Red Cross, and so we're very grateful for this this new gesture of friendship today and helping us to understand a bit more about international humanitarian law. Thank you, Sir Ken.
Well, thank you very much. It's a great privilege to talk to you about this critical body of law. Now, the title is Basic Rules of International Humanitarian Law in Armed Conflicts, or it would have said some years back, in war. And you may well ask, how can there be any rules applicable in time of war? Well, not only there can be, but there are, and there have been for a very long time. You can find instances of the applicability of principle of rules going back many centuries. To go back just 6 centuries to the Battle of Agincourt, you find this particularly in the version by William Shakespeare, Henry V. You will find there the law of arms, as it was called then, being applied in all kinds of ways to protect, for instance, the heralds that went back from one side to the other, to protect children who were looking after the files at one side or the other, to provide for the protection of the wounded, particularly for the recovery of information about the dead. And so I'll pick up on some examples from more recent times, but you can, as I say, go back a very long time. The rules reflect the fact that there is a balance in warfare between humanity and military necessity. That balance has been struck down the years, and you find the word humanity at least as early as 1864 in the first Geneva Convention, which I'll mention in a moment. There was a very important statement made in 1899 at the Hague Peace Conference to the effect that, to the extent that rules were not adequate to cover a particular situation, then individuals would be protected by the principles of humanity and the dictates of the public conscience. So there are these principles as well as the rules. Now you have the 7 rules in front of you, and to further simplify things, I will take them in 3 clusters. But you have in front of you as well these great big volumes, the handbook of the International Red Cross and Red Crescent movement, the 1949 conventions, the 1977 protocols, additional protocols to the 49 conventions, and these large volumes which include a great deal of customary practice, and they're being further elaborated. So there's a whole lot of detail, but underlying that detail are these basic principles, these basic rules. And let me take you back somewhat over a century to 1859, which marks one of the really critical stages in the development of this body of law. There was a massive war in Solferino in the north of Italy between the forces of Napoleon III and the Austro-Hungarian Empire. Both those armed forces were led by their heads of state by their, in the case of the French, Napoleon III. In the case of the Austro-Hungarian Empire, the very new emperor of the Austro-Hungarian Empire, who lived until the time of the First World War, Franz Joseph. And so you had this massive conflict, with at the end of which there were 30,000 casualties. And upon that site came Henri Dunant, a Swiss businessman who was wanting to get financial support from Napoleon III for his developments in Algeria. Well, that didn't happen. Instead, Dunant became committed at that particular moment, to giving assistance to the victims, to those who were still living. And he organised people in the local villages to provide assistance to those people, and to provide assistance without discrimination. And so you find in basic rule number 1, that reference to people being treated humanely without adverse distinction. He was using the Italian phrase tutti fratelli, we are all brothers. And so people who were outside the combat, outside the battle, are entitled to respect, and that proposition was established in a practical way right there. Now, his work, particularly his book, which I think I have here somewhere, A Memory of Solferino, originally, of course, in French, translated later, was a great call to the world community to say, let's set up organisations nationally, and that led as well to international organisations, to the International Committee of the Red Cross, being established in 1863 by Dunant and 3 other Swiss citizens. It's a curious body, not completely intergovernmental, but not a non-governmental organisation either. It has a unique status. And so that body got established in 1863. And at that time, there was occurring the war, the terrible war in the United States, the Civil War, in which more Americans were killed than in any other of the wars in which the United States has engaged. In 1863, a brilliant professor of many subjects who happened to be born in Berlin and happened to have fought against Napoleon at Waterloo, this now older man with 3 children was asked by Lincoln, by President Lincoln, to prepare general orders that became General Orders 100. And he set out the rules for the armies of the North. He had a particular interest, not only from his academic studies, from his own youthful warfare experiences, but also from the fact that he had children, 2 sons fighting for the North and 1 fighting for the South, for the Confederacy. The one fighting in the South was killed in the course of that conflict. And so he elaborated those rules. In 1864, to come forward a little and to pick up a New Zealand side of it, there was the Battle of Gate Pa. And in that battle, the Waikato side, through rules that are written and which you can find in a very good Red Cross publication, the Waikato side wrote down rules very similar to those that were written just a few months later in the First Geneva Convention in 1864. They said, for instance, that children and women were to be spared. Unarmed Pākehā, women and children will be spared, they said. Those who are wounded and captured will be spared, and soldiers fleeing to a church will be saved. We will not go there. And so principles were being stated and were being applied on the battlefield. Now, that's really covering much of rules 1 to 3. 4 and 5 pick up on the fact that people are going to be captured and people are going to be subjected maybe to trial, if you look at number 5. And so there, what is contemplated is the situation of prisoners of war. And I'll mention later civilians in occupied territories as well. And so there were some basic rules written in 1899 and 1907 about the protection of prisoners of war. But in 1929, that was further elaborated. And you'll see there a number of important things. There's a protection against all acts of violence and reprisals. Now, reprisals were once seen as a means of getting compliance with the law. It was a tooth for tooth, an eye for eye idea. If you break this rule, we will break it in response. Now, reprisals have been largely prohibited as a matter of law. As a matter of fact, things may well be different, but as a matter of law, they have been prohibited. There's also the very important practical business there of having the right to correspond. And in the Great Red Cross Museum in Geneva, you will find files, boxes and boxes of information about individual soldiers who corresponded with their families. These letters went backwards and forwards, and they were recorded in many cases by the International Committee of the Red Cross. One spectacular example on display there is for Charles de Gaulle, who was a captain in the First World War, later, of course, president of France in the 1960s, and a war leader in the Second World War. Well, de Gaulle was captured in the First World War, and you can track the correspondence that he had with his parents there. There's also a prohibition there on torture, and that has an interesting resonance in respect, again, of Francis Lieber, the man who wrote General Orders 100 back in 1863. In the Civil War in the Philippines in 1901, after the United States had beaten the Spanish and had taken over the Philippines, in that Civil War, there was an American military officer who was prosecuted for torture. It was torture by way of waterboarding. And the prosecution was brought under an updated version of what Lieber had written back in 1863. The prosecutor was one of his descendants. And so there you find the Liebers making a contribution in 1863 and then again in the early 1900s. And you have that major contribution by the United States to the writing of this law. There's also there a reference to the possibility of prosecution and the protection of fundamental judicial guarantees. Now, the final two statements are about what actually happens on the battlefield. Most of what I've been talking about is what happens around the edge of the battlefield. It's about people who are injured. There's also a convention back in 1899 relating to those who are shipwrecked and in need of care on the oceans. But it's people who are outside the battlefield. That was the traditional Geneva law. The Hague Law of 1899 and 1907 attempted to regulate what happened on the battlefield. No poisons, for instance, and matters of that kind. There were principles being developed there as well, and you find those principles stated here. For instance, under 7, parties to a conflict shall at all times distinguish between the civilian population and combatants. And you find spectacular instances of that principle being acknowledged and too often being breached. There was, for instance, a proceeding brought in courts in Japan in 1963 relating to the atomic bombing of Hiroshima and Nagasaki. And the court found against the plaintiffs, the survivors and family members, those affected by those two atomic bombs. They found against them for technical reasons. But in the course of that judgment, it was a judgment given on the 7th of December 1963. And if you think about the 7th of December 1941, you may see a certain sensitivity on the Japanese side to what happened at Pearl Harbor a couple of decades earlier. What that court said was that there had been a failure to comply with basic principles, with the principles of distinction. You have to target when you're using aerial bombardment. You have to use weapons that do not have radiating effects, as it was discovered later. And it's interesting to go back in that context to look at what was said by the Japanese on the diplomatic protest just immediately after Hiroshima. There must have been some busy people in the Foreign Office of Japan. I think on the day of Nagasaki, a note went off to the International Committee of the Red Cross and to the Swiss government to be passed on to the Americans to say the weapons that you have used or the weapon you have used in Hiroshima is in breach of basic principle. Well, one of the things that happened in 1977 in the updating of the conventions was to elaborate a set of rules to deal with aerial bombardment, with the use of aircraft, the use of helicopters, the use of new weaponry. And so you find a lot of detail in the 1977 additional protocols elaborating that. You also find there a real elaboration of the law relating to internal armed conflict, to civil wars. That was dealt with only briefly in the 1949 conventions, but by 1977 it was plain that internal armed conflict, civil wars of the kinds that we still see terribly being waged at the moment, that body of law had to be elaborated. So we have these very important instruments, and the last thing I wanted to say a word about was how do we enforce these things. There is an obligation on states to instruct their troops to engage in educational efforts more widely. There is provision for prosecution, for courts martial. There's the possibility of international tribunals trying people for breaching these rules, as has happened in respect of former Yugoslavia, Rwanda, Sierra Leone, Cambodia, and now it's available generally in the International Criminal Court. But there could be prosecutions or courts martial at the national level too, as happened, for instance, after the American Civil War. And New Zealand military have sometimes been subject to that kind of process. So there's the possibility of prosecution. There's the possibility of the International Committee of the Red Cross playing an important role, or the actuality of that, in terms of trying to get better compliance. There's also an obligation on national societies to make this body of law better known and better understood. And in a way, that's what this webinar is about. So there is a range of ways in which the law can be implemented and people can be better informed and people can be better trained. And there are some good examples of that happening. Unfortunately, there are many examples of breaches, but compliance can be seen in many of the most deadly conflicts. And there are the processes after the event sometimes for those matters being addressed. For instance, in my time in the International Court, these were after the event, cases, we did look at what had happened in former Yugoslavia in the wars between Bosnia and Herzegovina on one side and Serbia on the other, and between Croatia and Serbia. And so, in that way, as happened in Nuremberg and Tokyo after the Second World War, sometimes there will be an historical accounting. Doesn't do anything very much for the people who were killed, but there is then a historic record of the failures of states and parties to armed conflict. So there's my rapid run through those fundamental, those basic rules, which are of huge importance and which require greater and greater support and more extensive knowledge. So.
Thank you so much, Sir Kenneth. I think we would all agree that was an astonishingly succinct range over a vast amount of history and territory. May I just check, are our colleagues who are watching us remotely, are they able to see Sir Kenneth on their screens?
Yes, I'm quite sure they are, but we can ask them to type it as a question if they can see the video properly.
Super, and yes. And we have now an opportunity for a few minutes for questions. So perhaps while our colleagues who may be remote are thinking of a question to type in, and I believe, Jorge, the protocol is that they have to push something that says raise their hand, yes. Is that right? Okay. We'll wait for a few minutes for questions from colleagues who may be remote, but perhaps we could open up the floor for our colleagues who are here with us. Are there any questions from the floor to start things off?
Well, this might be, there's no double questions, this might be an irrelevant question, but is there any application for technological warfare, or could you see any development of these rules to reflect the changes in our societies and the way that we're doing it?
Well, that's certainly a very important point, and there is, for instance, a lot of work being done at the moment in respect of cybercrime and in respect of drones and so on. And obviously it's important to try to work up the detail in those areas. There are a couple of versions now of the Tallinn manual on cyber warfare, for instance. They're not, those documents don't purport to be legally binding, but they're an attempt to elaborate the relevant principles or to apply the relevant principles. Because to go back to the Hiroshima and Nagasaki sort of example, or all the detailed rules that have been written more recently about napalm and other weapons, it is possible to run back to those old principles, the principle of distinction, the principle prohibiting poisons, the requirement that you've got to target accurately, that you've got to have a weapon that is not indiscriminate. This is one area in which discrimination is a good thing, because usually if you're seen as discriminating these days, it's a bad thing, isn't it? In the case of the use of deadly force on a battlefield, you have to discriminate. You have to discriminate between the people who are combatants and the people who are civilians, as NRA Taratoa did. And also thinking of the image of the ambulance, the Red Cross ambulance riddled with bullets, and I should have mentioned the importance of the symbol, the Red Cross, the emblem of the Red Cross. There you've got something that shouldn't have been targeted. The first 1864 convention is designed to protect those who are going about their business of assisting the injured, the wounded, the people who are outside the conflict. And that convention also protects any civilians who may assist in that endeavour. And there's a call way back then from military commanders to call on the humanity of the individuals in the district to provide that aid and to say that they are protected from any retribution by the local authorities because they might be helping injured people from on the enemy side.
Sir Ken, you sometimes say that IHL is the single distinct feature of the Red Cross. I wonder if you would comment further on that.
Yes, well, it is the case that the Red Cross does have this, the ICRC does have this very special role. As I said earlier, in a way it's neither fish nor fowl. It's not an international organisation, and it's not a purely national one either. It's not a non-governmental organisation. And it does, of course, a whole lot of other things. If you think of disaster response and relief and so on, or Meals on Wheels, or a great range of things that Red Cross does. But it does have this unique role compared with all the other great agencies, like UNICEF or Save the Children or Oxfam and so on and so on. It does have this unique role on the battlefield, and that's expressly recognised in the conventions. And the symbol is there along with the Red Crescent. The Red Cross, as you probably all know, is not a religious symbol. It's simply the Swiss flag reversed. But people on the battlefield have felt reluctant to use the cross. They've used the crescent instead. And that wasn't formally recognised until, I think, the 1929 convention. But on the battlefield, say at Gallipoli, the New Zealand forces did, of course, recognise the Red Crescent. Otherwise, they'd be fearful that the Red Cross would not be recognised and its protective value. And there was, for a long time, an argument about having a third symbol, and there is a red crystal, but I don't know that it's been a matter of any great practical value.
Thank you. Okay.
I do have a question from Lynn Dawson, and she says, you spoke of individual humanitarian initiatives in various wars. Does this still happen? What about ISIS current warlords, like in Afghanistan and Syria?
Well, there are individual initiatives, aren't there, by bodies like Human Rights Watch and Médecins Sans Frontières and so on. There are the bodies that do try to assist around the edges of battlefields, or sometimes actually on the battlefields. But your reference to ISIS and so on takes me back to the point that I touched on only briefly at the end, and that is the point that this body of law has now been extended to cover wars that may be seen as civil or internal, hardly civil, but internal, not international. Although at times it's really very hard to determine whether a body of law is a particular armed conflict, rather, is international or purely national, purely domestic, purely internal. And one of the interesting things that has happened is that although the conventions are drafted on the basis that there are these separate categories, many of the rules that you'll find in this big customary law study now indicate that the same rules apply nationally and internationally. And that is the situation too in respect of much of the jurisdiction of the tribunals that are now completing or have completed their work in Rwanda and former Yugoslavia, and the International Criminal Court too. Its statute doesn't make such a clear distinction between international and non-international armed conflict as once was considered to be the case. But there are obviously real problems in getting some non-state groups to comply with the body of law, as the question indicates.
Thank you. Any more questions coming remotely?
Not from our remote. Yes.
And any more questions from our colleagues here?
I've got one.
Go ahead, Elodie, just one last question.
Yeah, sure.
Yeah.
I just wonder what will you say to Kiwis out there who know nothing about international humanitarian law on the reason why we should all know a little bit about IHL and why as a Kiwi may not work in law, anything related to Red Cross, why we still should know a little bit about it.
Well, it's partly to remove the cynicism, you know, the wars are just unlimited slaughter, and to show that in the midst of obviously terrible human suffering and great destruction of important property and so on, that there are these rules, that human behaviour does have its limits, that wars do have limits. And it's also something which is important for New Zealand's international reputation as well, that our military, when they serve abroad, have to comply with these rules. The inquiry in respect of the incidents in Afghanistan, for instance, highlight that. There were situations in the Second World War in Italy where New Zealand forces misbehaved in respect of some German POWs they were holding, and the next morning the New Zealand positions were overflown by German planes which didn't drop bombs. They dropped bits of paper saying, "We didn't think you behaved this way. And if you continue to do this, there will be retribution," notwithstanding the prohibition on reprisals in respect to POW. So there are very important principles that should be part or are part of our national identity. And it's part, as I indicated too, of our purely local identity in terms of the wars that were fought between Maori and the settlers, or British troops and the settler troops, and back in the 19th century. So there's and to take another New Zealand example, there was the important inquiry undertaken by the Swiss government into the shooting, the riot, the shooting that occurred in Featherston with Japanese POWs. The Japanese had not signed up to the 1929 POW Convention, and their whole military tradition was against being captured. Much better to die than to be captured. And so you see a slow growth and important historical growth, that some of the savagery of warfare of the past has been to some extent moderated, and New Zealand's played an important, a significant part in quite a lot of that.
Thank you. Sir Kenneth, on behalf of all of the people who are here and all the people who are sharing this webinar remotely, may I say thank you for your time today, but also I think quite evidently to all of us, your service to international law through your career and your friendship with the Red Cross. Thank you.
Well, thank you.